Good morning, everyone. My name is Marty Rabinovitch. I am a partner at Devry Smith Frank, and I head up the employment law group here at the firm. So welcome again to today's seminar. For those of you who don't know, Devry Smith Frank is a full service firm. We have offices in Toronto, Barrie, and Whitby, and a number of other offices throughout Ontario. We typically do these seminars once every few months, and this seminar is the first sort of year-end review or top 10 list that we will be doing. So I hope you enjoy it and find it informative, and hopefully there will be many more of these to come. So again, welcome. And for human resources professionals who are attending today, the program has been approved for CPD hours for you. So the code will be available after the presentation. And for lawyers out there, the program qualifies and has been approved for one substantive CPD hour through the Law Society. Here is today's agenda. We will start with some brief opening remarks, which will conclude shortly. We will then get into the content. So we will look at the top 10 employment law decisions of 2022. We will then have a Q&A period for approximately 10 minutes. So I'll just start by saying, first of all, the most frequently asked question that we get at these seminars is whether or not the slides will be available. And the answer is yes, they will be available after the presentation. So not to worry, they will be available on our firm's website, and we can also either email you a copy or share the link with you. I will answer as many questions as possible during the Q&A period, but if I don't have time to get to your question, or if you prefer to email me directly with your question instead, that works too, and I will answer your question offline a little bit later. And then we will conclude the seminar at about 11 o'clock after some brief concluding remarks. So without further ado, let's get right into the top 10 employment law decisions of 2022. So the first case that we are going to look at is called Curry and Nylene. It's a 2022 decision of the Ontario Court of Appeal. So in this decision, the employee commenced an action for wrongful dismissal damages. She was terminated from her employment without cause. The employee was 58 years old at the time of dismissal and had worked for the defendant employer throughout her entire career in a very specialized manufacturing field. And the employee's argument was that due to her age, experience, training, and qualifications, that she should be entitled to a common law reasonable notice period of 26 months. Now, by way of brief background, at common law, 24 months is what I'll call the unofficial cap for the common law reasonable notice period. And as we saw in 2019, in a Court of Appeal decision called Daw and Equitable Life, the court made it pretty clear there that in order for a common law reasonable notice period to exceed 24 months, that there had to be really some exceptional circumstances. So back to Curry, at trial, the court found that yes, there were exceptional circumstances that were present in the case to justify a 26-month notice period. And the factors that were outlined by the court were the plaintiff's age of 58, that the employee worked in had highly specialized work skills in fiber production operation. She had only worked with one employer throughout her entire career, which would make it more difficult to find a new job. She only had a high school education and skills that were not easily transferable. So the employer appealed and argued that there were really no special circumstances here that would justify exceeding the maximum of 24 months. But the Court of Appeal ended up upholding the trial judge's decision and agreed that there were, in fact, special circumstances. So the takeaway from the Curry case, this is an example of a situation where the courts have deviated from the accepted common law reasonable notice cap of 24 months. And it's an example of what the court has found to be exceptional circumstances, which would justify a higher notice period. Moving right along, we will look at another Court of Appeal case called Taylor and Hanley Hospitality, Inc. In this case, we had an employee who was placed on a temporary layoff due to a workplace closure during the COVID-19 pandemic, and the plaintiff commenced an action claiming constructive dismissal. The defendant's position was that the relevant regulation with respect to idle or infectious disease emergency leave should apply not only to constructive dismissal under the ESA, as it clearly did based on its wording, but they also argued that that regulation should effectively displace the common law, which has consistently held that employers do not have any inherent right at common law to lay off an employee. Now, before this case, there were decisions of Coutinho and Fogelman, which had previously determined that the regulation about idle did not prevent an employee from pursuing a common law constructive claim. So at trial, the court found that there was no constructive dismissal, so it differed from the decisions in Coutinho and Fogelman. And the court in this trial decision found that, in fact, the regulation did just the opposite of what the courts had concluded in the other cases. So in other words, that absolutely this regulation displaced the common law, and there couldn't possibly be a common law claim for constructive dismissal. And also the Superior Court didn't agree with the other two decisions analysis in section 8 sub 1 of the ESA with respect to whether or not a regulation could displace the common law. Now, on appeal in Taylor and Hanley, the Court of Appeal set aside the trial decision on other grounds and ultimately did not answer the question of whether or not an employee could claim common law constructive dismissal in response to being laid off under the idle regulation. So the case gets sent back to the Superior Court to be re-adjudicated. So right now, I would say there is some uncertainty in the law. I'm not sure that we've heard the last of this. There's likely to be some other court decisions on this issue, and one of those might make its way back to the Court of Appeal. I'm not sure that Coutinho and Fogelman are necessarily going to get there. But currently, Coutinho and Fogelman are the cases that govern the law on this issue. And simply put, the law right now is that the idle regulation in section 50.1 of the Employment Standards Act do not displace the employee's common law right to assert constructive dismissal. Okay. The next case we will look at is called Render and ThyssenKrupp Elevator, another Court of Appeal case. So here we had an employee who worked for the employer for about 30 years in a managerial role. He is involved in an incident where he slapped a female coworker on the buttocks and gets terminated for just cause. Now, a little bit of background here is that in this particular workplace, the evidence was that there was a history of what I'll call sexualized banter. So the employees, I think, would regularly engage in, back and forth comments, which were, in most cases likely inappropriate and probably would fall under the definitions of harassment or sexual harassment. So this was a specific working environment already, which likely was not in compliance with the relevant laws. The trial judge concluded that the one single incident was enough to justify dismissal for cause because it caused a breakdown in the employment relationship. And on appeal, the employee argued that this was a mistake and there should not have been just cause. So just a little more background, the incident that led to the termination, ironically, did take place in an elevator, and there was some sexualized banter going back and forth, and the female coworker whose buttocks were slapped apparently made some comment towards the employee who got fired about how short he was or something to that effect. And then, he kind of, felt a little bit slighted, but, nevertheless, went along with the joke, went down on his knees and, made some comment about, well, how short am I now? And then that's what led to the slap on the buttocks ultimately. So the Ontario Court of Appeal does uphold the termination of the employee, even though it was a 30-year employee with only one incident. And I would say that this absolutely is a significant departure from previous cases on just cause termination. Before this case, my prediction would have been that if you have an employee who's worked somewhere for 30 years and they've engaged in one incident of misconduct, that probably based on the proportionality principle that's set out in McKinley, that probably would not have been enough to justify cause. However, the Court of Appeal disagreed here, and the Court of Appeal cited the seriousness of the conduct, the non-consensual touching, the employee's lack of remorse, which was also a good one. Important factor, the Ontario Court of Appeal does uphold the just cause termination. But we're not done yet. There's more in the case, right? The court then goes on to say, well, there was just cause, so the employee is not entitled to a common law reasonable notice period. However, we are going to award the employee their minimum entitlement for termination pay under the Employment Standards Act, which in this case amounted to 8 weeks. So the Court of Appeal found that the employee's conduct did not quite meet the willful misconduct threshold. This is a separate standard that an employer must meet in order to deprive an employee of their minimum entitlements under the Employment Standards Act. The full wording of the test there is set out here in bold on the slide. Willful misconduct, disobedience, or willful neglect of duty, that whole mouthful there. The court found that that standard of willful misconduct was not met. And just as a quick note, I mean, ThyssenKrupp does have an annual payroll of at least $2.5 million, or at least I would have thought that they did. But because there was no evidence presented to the court to this effect, there was no award for ESA severance pay. Had there been evidence that ThyssenKrupp had an annual payroll of at least $2.5 million, then the severance pay would also have been awarded. So the willful misconduct standard is higher than the just cause standard. And really the willful standard, it involves a degree of intentional, deliberate, and it involves, by definition, an assessment of the employee's subjective intent. But interestingly, the Court of Appeal seems to have introduced this new element of the conduct being pre-planned. So the Court of Appeal did note in its decision that the appellant's conduct was done in the heat of the moment, which I guess means that, the plan was not for him to engage in the inappropriate touching. It was sort of a situation that happened, which led to it. So the two key takeaways, I think, from this case are: number one, a single incident of sexual harassment, or possibly, other kinds of harassment, can result in termination for just cause. And number two, there now seems to be a pre-planned element in the willful misconduct standard under the Employment Standards Act. We will move right along to the next decision, which is called Raman and Cannon Design Architecture, Inc. This is a 2022 decision of the Ontario Court of Appeal. So it's another wrongful dismissal case. The employee argued that the termination provision, which was limiting her entitlement, ought to have been found unlawful based on a Waxdale violation. So that's a reference to a 2020 Court of Appeal case. And the rule in Waxdale is effectively that if any part of the termination provisions offend the ESA, then the entire termination scheme would be unenforceable. Now, at trial, Justice Dunphy, who, by the way, has a reputation for being a very pro-employer judge, found that the termination provisions complied with the ESA and concluded that they governed the plaintiff's termination. Now, in arriving at this decision, Justice Dunphy found that the plaintiff had obtained independent legal advice about the offer, was a woman of experience and sophistication, and that the party's subjective intention was to comply with the ESA minimum standards, even though, based on a review of the language, the language almost certainly would have been unenforceable based on Waxdale. So, not surprisingly, the Court of Appeal overturns the trial decision and concludes that there were ESA violations and that the entire termination scheme should be void. Now, in particular, the Court of Appeal concluded that the employee's level of sophistication and the fact that she obtained independent legal advice are irrelevant when determining whether the termination language itself is enforceable. So really, at the end of the day, this is an application of the principles that are outlined in Waxdale, where an unenforceable termination provision was found to invalidate the entire termination scheme. Okay. Moving right along to case number 5. This is a case called Wylgosh and London District Catholic School Board. It's a 2022 decision of the Human Rights Tribunal. So in this case, the HRTO, or the tribunal, addressed the issue of whether it had jurisdiction to hear human rights matters raised in 2 applications involving unionized employees. And the issue to be decided was whether the allegations made under the Ontario Human Rights Code fell within the exclusive jurisdiction of a labor arbitrator, or whether the tribunal had concurrent jurisdiction to adjudicate human rights complaints made by unionized employees directly against their employers. So Wylgosh had to address how the relatively recent Supreme Court of Canada decision in Horrocks would apply in Ontario. So in Horrocks, the Supreme Court found that the Manitoba Labor Relations Act, similar to the Labor Relations Act in Ontario, did grant exclusive jurisdiction to labor arbitrators over all disputes arising from collective agreements. However, that other statutes might carve into that jurisdiction if this was the clear intent of the legislature. Now, in this decision, the tribunal determined that it continues to have jurisdiction to adjudicate human rights complaints advanced by unionized employees, despite the Supreme Court of Canada decision in Horrocks. And the tribunal found that the broad language used in the Human Rights Code regarding certain deferral and dismissal powers, so that's at sections 45 and 45.1 of the code, demonstrated that the Ontario legislature did intend for overlapping jurisdictions. So in other words, if there's provisions in the code about the tribunal having the authority to defer a complaint in certain circumstances or to dismiss an HRTO complaint altogether if the subject matter has already been dealt with in another proceeding, then it would appear that this contemplates scenarios in which there could be concurrent or multiple proceedings. So I mean, this decision makes sense to me. So at the end of the day, the case confirms that unionized employees in Ontario who work for a provincially regulated employer, federal is different, continue to have the right to file human rights complaints directly against their employer to the Human Rights Tribunal. And similarly, labor arbitrators also continue to have jurisdiction to adjudicate human rights issues in the grievance arbitration process. We will now move right along to a case called Bowen and J.C. Clark Limited. This is a 2022 decision of the Court of Appeal as well. So here we had two portfolio managers who were making a complaint against their employer for wrongful dismissal and also a claim for $1.3 million in performance fees, or effectively bonuses. The managers had entered into an agreement with a senior investment professional where the professional intended to share 50% of his management fees and all of his performance fees with them. The managers then entered into employment agreements with J.C. Clark, which provided that at the total discretion of the company, you may be eligible for a bonus at the end of each fiscal year, depending on factors that include your personal performance and profitability, so these are factors that are specifically mentioned here. At trial, the court dismisses the manager's claim, and the reasoning was that the investment professional had paid them performance fees to which they were entitled, and they weren't entitled to anything directly from J.C. Clark. And the trial judge determined that the managers had signed employment agreements with J.C. Clark, or the agreements they signed did not say anything about performance fees being paid by J.C. Clark. But now at the Court of Appeal, the decision gets overturned, and this case is really a good reminder that employers must exercise fair and reasonable discretion when awarding discretionary bonuses. And what constitutes a fair and reasonable exercise of discretion is very much dependent on the facts and circumstances of the case. So when we're dealing with discretionary bonuses, I mean, many of these factors, would be set out in a contract. And as an employer, if you have certain factors that you would like to be considered, I mean, always a good idea to set them out in the contract. But some of the factors are the company's performance, individual performance, seniority, position, and length of employment. So this case is a reminder that discretion with respect to bonuses needs to be exercised reasonably. Okay, and a recap here about some of the criteria that we just went through in determining discretionary bonuses. Number 7 is a case called Lake and La Presse. Lake and La Presse, 2022, Court of Appeal. So it's another wrongful dismissal action. After the termination, the employee remains unemployed as of the summary judgment motion date, which was approximately 2 years after the initial dismissal. And while there was no dispute that the plaintiff was terminated without cause and that she was entitled to reasonable notice, the issues at the summary judgment motion were, number 1, the length of the common law reasonable notice period, and 2, whether the plaintiff's notice period should be reduced for failure to mitigate. So the court goes through the typical Bartle analysis and concludes that the notice period should be 8 months. Okay, but then the trial judge looks at the employee's mitigation, okay, and notes the test. So first of all, the employer has the one with the duty to show that the employee failed to mitigate. And the two-part analysis is, first of all, whether the employee's mitigation was overall reasonable. And number two, if those reasonable steps had been taken, would the employee have likely obtained comparable employment? So the motion judge was actually fairly difficult on the employee with respect to her mitigation efforts. He says, well, the employee overall didn't take fully reasonable steps because she waited too long before beginning her job search. She aimed too high and was only seeking out more senior roles. And as a result, the judge says, well, at trial, normally I would have awarded you 8 months, but now I'm reducing it to 6 months on account of the employee's failure to mitigate. But then this gets overturned on appeal in an employee-friendly decision that we are used to seeing. So the Court of Appeal basically says, no, the trial judge was a little bit hard on the employee with respect to her mitigation efforts. So the Court of Appeal says, well, I agree with the trial judge's analysis that 8 months notice was correct, or was at least within the right range, but there's not going to be any deduction for the employee's mitigation efforts here. So the employee is only required, as we see here, to seek comparable employment, and comparable is defined in terms of status, hours, and remuneration. And the Court of Appeal found that the trial judge ultimately put too much emphasis on the titles of the positions for which the employee applied and failed to properly consider that these positions were in fact quite similar to her prior job. So the takeaways here, just reminders that when we're talking about mitigation and comparable employment, that is the threshold. An employee does not have to apply to every single job out there that is not comparable, having regard to the position, the salary, the hours and whatnot. The employer is the one who has the burden to prove that the employee has failed to mitigate. And as a point of strategy, the employer, as part of their ability to prove or to try to prove failure to mitigate, one possible strategy would be for the employer to locate job listings for comparable positions and then send them to the employee or to their lawyer and say, hey, I just found 5 comparable jobs to the employee's last position. Have you applied for these jobs? And if not, please do, because you have a legal duty to, as part of the duty to mitigate. Case number 8 is called Dagenais and Pellerin, another Court of Appeal case. And this case addresses the question of the scope of vicarious liability of an employer for the wrongful acts of an employee in the course and scope of their employment. So the employee had been instructed by his supervisor to travel to a job site 2 hours away. And while traveling, the employee decided to stop at Tim Hortons for a coffee and to stretch. And unfortunately, as the employee who was driving attempted to turn off the highway, he struck another vehicle. So there was an accident. So in Dagenais, the Court of Appeal set out the test for vicarious liability from a case called Salmond. So employers are vicariously liable for, first, employee acts that are authorized by the employer. And there's the second part of the test that's a bit of a mouthful, but basically unauthorized acts so connected with the authorized acts that they may be regarded as modes of doing an authorized act. Okay. So What does the Court of Appeal do? The Court of Appeal upholds the trial decision, which found that the employer was vicariously liable. And the reasoning was that in terms of what the employer's authorization was that yes, the employee had to drive a couple of hours to the job site, but the court said, look, within that authority, the employee was very much entitled to drive off the highway, go have a coffee break and stretch their legs. And this small detour was by no means a frolic of the employee's own. So unfortunately, if an accident happened, that would be the employee acting in the course of their employment, and the employer would be liable. So we know that employers can be held vicariously liable for their employees' acts or omissions in certain circumstances. Just a point here about insurance coverage. So, the best defense as an employer, in particular, if you've got employees who need to drive for work, make sure that adequate insurance coverage is in place so there's no surprises when it comes to lawsuits. And then employers should also be thinking about their employment contracts here. And if there are concerns, specifically what sorts of employee actions, will and will not be considered in the course of their employment. Moving right along to case 9. So for 9 here, there's going to be a 9A and a 9B. So you get one bonus case this morning, and you'll see why we've grouped these two cases together, I think, pretty shortly. So the first case is called Parmar and Tribe Management, Inc. It's a decision of the British Columbia Supreme Court, which is basically their equivalent of the Ontario Superior Court. So the issue here was whether placing an employee on unpaid leave due to a refusal to get vaccinated against COVID-19 in accordance with a mandatory vaccination policy amounted to constructive dismissal. So in Parmar, the employee fails to comply with the mandatory vaccination policy and gets placed on an indefinite unpaid leave. And the employee says, well, that's unreasonable. I don't like it. This amounts to constructive dismissal. So that was the issue that the court had to address in this case. So just a little bit more background here. So Tribe Management, the employer, provided condominium management services, which was deemed to be an essential service in British Columbia. And then the employee was an accounting professional who was employed as a controller at the time. So the court ultimately dismissed the plaintiff's constructive dismissal claim and found that the mandatory vaccination policy was lawful and was reasonable. And in doing so, the court took judicial notice that COVID-19 is an easily transmissible, potentially deadly virus, and that vaccines are safe and effective. And at the time that the vaccination policy was implemented, it was in 2021. So specifically, the policy stated that employees were required to be fully vaccinated. So in other words, 2 doses at that time. And the deadline for doing so was November 24th of 2021. So that I believe that was in Delta variant times and the initial rise of the Omicron variant. Now, case 9B here is an arbitral decision in Ontario that involved the firefighters. And in this arbitral decision, the arbitrator found that a mandatory COVID-19 vaccination policy implemented by the City of Toronto in 2021 was also reasonable. So in other words, putting an employee on unpaid leave if they refused to comply was reasonable. Now, the arbitrator found that although the vaccination policy was reasonable, so meaning requiring the firefighters to be fully vaccinated in order to work, that was reasonable. The arbitrator did take issue with the enforcement mechanisms in the policy, which included disciplinary suspensions and discharge for non-compliance. So the arbitrator did find those to be unreasonable. And this policy, very similarly to Parmar, required the employees to be fully vaccinated, 2 doses, by December 31st of 2021. So based on these 2 cases, it seems like, where the law is headed on this issue is that if you have a mandatory vaccination policy as an employer, and you have an employee or employees who are refusing to comply, based on these 2 cases, the safest route, legally, and to have the health and safety standards in the workplace upheld would be to place the employee on an unpaid leave of absence until either they change their mind and comply with the policy, or the requirement in the policy is either revoked or amended such that there wouldn't be any employee breach anymore. So these cases are saying that the requirement to be fully vaccinated with 2 doses as a condition precedent for employees to continue working was reasonable and continues to be reasonable, but disciplinary measures were not found to be reasonable in the Toronto firefighters case. So again, just to highlight that the facts that gave rise to these decisions did occur in 2021 during the height of the COVID-19 pandemic. However, these cases are still relevant and do provide important precedents for mandatory vaccination policies in the context of either another contagious and deadly COVID-19 variant, or potentially even another pandemic caused by a different disease for which vaccinations are or become available. And then finally, the last case we are going to look at before we open the Q&A period. So again, just a reminder, submit your questions if you have any. The last case we're going to look at is called Gracias and Dr. David Walt Dentistry, a 2022 Superior Court case. So it's another wrongful dismissal case. The issue was with respect to, first of all, the termination scheme, and secondly, whether the employee was entitled to an increased notice period having regard to the COVID-19 pandemic. And specifically in this case, the court had to consider whether potentially offending termination provisions that were in confidentiality clauses and conflict of interest clauses, so not the termination clause proper, would render the termination scheme unenforceable. So the offending provisions can be found on the slides here. So the conflict of interest provision, the text is there, I won't read the whole thing, but it effectively says that if you don't comply, it's cause for termination without notice. Okay, so the issue is still whether or not, breaching a conflict of interest would rise to the willful misconduct threshold that we looked at previously. And same thing with confidential information. The clause says if you breach the clause, your employment will be terminated without notice for cause, without compensation. So again, there's that potential for it to offend the ESA willful misconduct standard. It's 2 separate standards. So with respect to the employment contract, the court reiterates the principle that in the absence of express and clear contractual language to the contrary, an indefinite term employee is entitled to reasonable notice of dismissal or pay in lieu thereof at common law. And similar to another 22 case called Henderson and Slavkin, the court found that unenforceable termination language, even if it was found outside, the termination clause specifically, still rendered the entire termination scheme unenforceable. Now, the issue about the notice period, the court fixed the plaintiff's entitlement to notice of termination at 3 months. And the discussion here is important because the judge found that while the effect of the COVID-19 pandemic certainly was harmful overall on a large scale for the global economy and domestic economy here in Canada as well, its effect on particular sectors of the labor market varied. So, for example, there was definitely a very high demand for healthcare workers. And in this case, the motion judge found that there was a robust market for dental hygienists, which did not justify a longer notice period. So the Gracias case, I would say, expands on and clarifies the principles outlined in Waxdale and Swagan. So specifically, termination language in other provisions of an employment contract, such as conflict of interest or confidentiality, can still render an entire termination scheme unenforceable if there is language which says if you breach that clause, we are going to terminate you, for just cause without notice. And again, the issue that the court has is that it's not clear that a breach of a conflict of interest clause or a potentially small breach of confidentiality would be sufficient to rise to the level of willful misconduct. And then finally, the length of notice periods for employees will ultimately depend on the industry itself. So I'm going to open the floor now for questions. So I will go to the chat now and try and answer as many questions as possible. Thanks very much for attending today. So we're going to move into the Q&A period now. So let's see what we have here. Okay, so the first question, please show the final slide of number 2 and review the decision in that regard. Okay, well, the second case, I will just, I've stopped the share here, but the second case that we looked at is Taylor and Hanley Hospitality, Inc. Really, the conclusion, I guess, that we are drawing from Taylor and Hanley, and to the person who asked that question, the slides will be available, and you can certainly review those slides later. But the conclusion in Taylor and Hanley is that because the Court of Appeal overturned that decision on other grounds, really the key factor to know is that the law currently is governed by 2 other cases, and those cases are called Coutinho and Fogelman. So in other words, Section 50.1 of the ESA and the idle regulation do not displace the employee's common law right to assert constructive dismissal. That is the conclusion. The slides will be available though, and you can certainly review those slides. Okay. Okay, there's another question that I see here about the PowerPoint presentation. Again, yes, the slides will be provided. Okay, so not to worry about that. They will be provided. They're going to be on the firm's website, and we can also email you a copy. Okay. Okay, there is a question here about the Gracias case. Okay, and the question says, if the conflict of interest or confidentiality clauses contained language like a breach of conflict of interest clause will be considered willful misconduct, and you will be terminated for just cause, might that have been accepted by the court? Well, that's That's a good question, but I'm not sure that most courts are going to be so happy and so giving in when it comes to employers trying to define or clarify a particular standard that's set out in the ESA. So I'm not sure that that has specifically been decided yet. But I would be careful about that. I mean, generally speaking, that there are ways of handling that. I mean, you have to draft very, very carefully to say that if the employee's employment is terminated, that they will be entitled only, to their entitlements under the Employment Standards Act. That is probably the safest way of drafting it to avoid having your entire termination scheme being thrown out. Okay, there are a few more questions here, which we will try to get to. The next one says, as to the termination clause, if it sets out situations qualified for termination under common law, but not falling within the scope of willful misconduct in the ESA, would the clause sustain? Would it be sustained, or would it be upheld at law? I'm assuming if it further clarifies that in such termination, the minimum notice period in the ESA, will be honored. So again, the safest way to do it, okay, is probably, again, if the goal is to limit the employee's entitlements to only, what they are, what they would be entitled to under the Employment Standards Act, you would want a provision. And for any employers out there who need assistance with drafting of their minimum ESA termination clauses, we do a ton of these, and we could absolutely help you with that. You would want a provision which says that, in the event of termination, the employee will be entitled, only, to their entitlements, under the Employment Standards Act. That's how you are going to effectively limit their entitlements. So I think that is the best way of doing it. To the person who asked me that question, if you have any follow-up questions or wanted to discuss that further, I would be happy to do so offline. There is another question that says here, if termination clauses for cause and no cause are airtight, but a separate clause about benefits says that the employer can terminate benefits at any time without notice, is this offside the ESA, and therefore can employees get common law notice? So I'm not sure. That's another good question to consider. I'm not aware of any cases specifically where that issue has been considered. What I do know, that there are many employment contracts out there that do say that, the employer does have the right to amend or revoke or, add to, presumably, the employment benefits that are being provided to the employee, pretty much at their discretion. So I mean, that will be an interesting issue to see if it makes its way to the courts. But for any employers who have a provision like that in their contract right now, you obviously want to be careful and obviously not change the benefit plan after a termination, because there are provisions in the ESA which say that the employer is not supposed to change salary and benefits and things like that. So Gary, thank you for that question. If you'd like to discuss that further offline, I'd be happy to do so. Okay. there's a question here about the CPD hours. So it's there's hours for both HRPA and for lawyers. It's 1 hour. Okay. Okay, I see 2 more questions here. One of them says here, hi Marty, what are your thoughts on calculating the amount of compensation on termination for a commission employee if the compensation is not standard? The ESA says to use the last 12 weeks. What if the employee made significantly more 1 year earlier compared to the amount they were making at termination? Right. So there is an Employment Standards Act way of calculating the commissions, but likely if there's going to be a common law reasonable notice, I mean, likely what the courts would want to see is they would look at the employee's overall earnings for probably the last, I don't know, probably 2 or 3 years, say. So the T4 income overall would probably be, what the courts would be interested in for the purpose of the common law reasonable notice. But if this is a case where there's an enforceable termination clause, then the ESA method is going to govern. Okay. The CPD code, I believe, will be provided through email. Yes, and if you don't receive the CPD code, you can contact, email info@devrylaw.ca, and they will get that to you, not to worry. Okay, and I see one more question here, and this one says, regarding the COVID vax policy case, what is your prediction in future cases regarding new studies contradicting the efficacy of the COVID vaccine, possible side effects, and whether the employer can be liable for vaccine injuries if such policy is enforced? Well, I mean, right now, I mean, the information that's out there scientifically, is that the vaccines are safe and effective and whatnot. I mean, if that information were to change, or there was something about unsafe vaccines or potentially harmful vaccines happening with with a future strand of COVID-19 or another pandemic altogether, I mean, that issue would need to be looked at. But I mean, in terms of vaccination policies, for the cases that we were looking at for 2021, I mean, if there were to be any new, scientific findings that were accepted, I don't think that wouldn't affect, those decisions that were made at that time, because based on the information available, the policies were found to be overall reasonable. So if you're looking at, whether or not any policy really, including a COVID-19 vaccination policy, is reasonable, you have to look at the facts and circumstances at the time, and the evidence then. And as I understand it, I mean, the evidence is still that the COVID-19 vaccines do continue to be safe and effective. And based on that, I don't really see any liability for employers who have introduced mandatory vaccination policies that have found to have been reasonable. Okay, so I don't see any more questions right now. So again, thank you to everyone for coming. Thank you all for your questions. If you have any other questions that you'd like to ask about this seminar, or any follow-up questions to what you asked, again, I am happy to answer those online or offline, sorry. So again, just to conclude, thank you all for coming. The CPD code, you only need one for the HRPA hours. The Law Society, as I understand, you can just report the program. Okay, the slides will be available online. at our firm's website. Okay, if you'd like a copy emailed to you, please feel free to get in touch with me at my email address, and we'd be happy to send you a copy. So again, our firm, we are a full service firm. Okay, we have offices in Toronto, Whitby, and Barrie. You name it, we probably do it. So if you need any legal assistance whatsoever, either with employment issues or any other issues, don't hesitate to get in touch with me. I'd be happy to direct you to the appropriate lawyer at our firm if it's not me. So again, we typically do these seminars. We typically do these seminars once every few months. So the next seminar is likely to be sometime in either February or March of next year. So keep that date in mind. And once again, thank you for coming, and happy holidays to everyone. And we'll see you all in the new year. Take care, everyone.